everyone. I'm Maggie LaBranch-Gonzales, and I'm an attorney with Litherland, Kennedy & Associates. We're an estate planning and elder care law firm located in Campbell, California. And today I'm going to talk to you all about powers of attorney. Not just any power of attorney, financial power of attorney, durable power of attorney, property power of attorney, all those powers of attorney. Let me share my screen with you because I have a little slideshow and I also have a whole bunch of frequently asked questions. So hopefully by the end of the webinar today that you will have all of this information and all of the knowledge you have about powers of attorney. So what is a power of attorney? It's a document that you use while you're living, but generally when you're incapacitated, you will appoint an agent or referred to as an attorney, in fact, to manage your finances, and it avoids a conservatorship if you are incapacitated. A couple of ways that it ends, the power of attorney ends, if you've revoked it, if you've regained capacity, which, believe it or not, does not happen that often. Maybe you've executed a new power of attorney, or you've gone and you've passed away. Yes, it happens to the best of us. That is right. Your power of attorney is no longer effective when you die. So what does it do? The property power of attorney or durable power of attorney, financial power of attorney generally manages assets that are not titled in the name of the living trust. In other words, they're all of the assets or things that remain in your name and someone needs to manage them for you. We see this a lot with retirement accounts. So your IRAs, 401ks, pensions, 403bs, annuities, those types of assets, your retirement assets, do not get retitled in the name of your trust. So if someone needs to manage them, for example, take your required minimum distributions, maybe update beneficiaries, then you're going to be using the power of attorney to do that. It also could be just paying your bills, your expenses, your credit cards, utilities, mortgage, insurance. Those sorts of assets, again, are also going to be in your name. If you're incapacitated or you need help, then you're going to have the power of attorney agent help manage those expenses because you won't be able to, or you've given them the authority to help you immediately. So what is it going to be doing? It allows your agent or attorney, in fact, to step into your shoes. Anything that you can do, generally your agent can do on your behalf. And again, this depends on the document itself, the type of power of attorney, but in general, this is what you're allowing your agent or your attorney, in fact, to do, to step into your pretty red pumps and basically walk in your shoes, right? Pay your bills, execute things, talk to banks, talk to that the cell phone provider that you have to spend an hour, those sorts of things without you having to do it as well. When does a power of attorney take effect? Generally, there's three types of power of attorney. There is an immediate power of attorney. That means it goes into effect as soon as you execute it. As soon as you sign it, that power of attorney agent that you've nominated under the document can now take it to a bank or make phone calls on your behalf because you've given them the authority immediately as soon as you sign it. There is a springing power of attorney. That generally means it's effective only upon incapacity. So it's not immediate. Something needs to happen. There needs to be a trigger of incapacity. You no longer have the ability to make your financial decisions, to pay your bills, those sorts of things. If you're getting a springing power of attorney, if you have a springing power of attorney, that means your agent or your attorney, in fact, will be required to typically have to get two doctor's notes that certify that you no longer have the ability to manage your finances. And then, right, and then here we go, that's the springing, that's the moment. Then they have the ability to step into your pretty red shoes, manage all of your finances for you. Our office does kind of a combination for married couples. We do a hybrid version. 96.5% of the time, we make it effective immediately for the spouse. Generally, 96.5% of the time, we trust our spouse for them to be able to step into our shoes at any point while we're living, not waiting for that incapacity. But for everyone else, the successor agents listed, the kids, the trusted person, whoever that is, it's effective upon incapacity. So it's immediately for the spouse and springing for everyone else. A little bit of a combination. However, like I said, it's not 100%. I have had some couples say they don't trust their spouse, so they have to wait just like everyone else for incapacity. It happens. The key here is you get to decide, and sometimes I've seen it transition over time. I have seen it start out as a springing power of attorney waiting for incapacity, but sometimes as we get a little bit older, maybe we need a little bit more help or we have kids that start helping us, then maybe it does transition. We execute a new power of attorney where it is in effect immediately. So I have seen it transition over time. People make changes. So it's not like you're set in stone because you've done a springing power of attorney and then later you decide maybe I need some help. Let's make it an immediate power of attorney. So there is some flexibility there. But, you know, there are so many powers of attorney. What do they mean? I'm so confused. Which one's right for me? So let's start at the top. Durable power of attorney. Durable power of attorney, what do you think about when you think of durable? Like long lasting, it feels good, right? We want it to last into incapacity, right? If you have a non-durable power of attorney, that means it's only effective for a specific purpose or specific time. If you have an estate plan or you're seeing an estate planning attorney, we're going to create a durable power of attorney. If you go to court or you have one and it's not specifically mentioned, it will be assumed to be a durable power of attorney. A non-durable power of attorney, like I said, is not durable. It's not long lasting. It's used for a specific purpose. So you can think of an example of maybe giving your stockbroker, right? For all of you who have these stocks and you're playing the market, you've given your stockbroker a non-durable power of attorney to help manage your day-to-day stocks. But once you're incapacitated, that power of attorney stops. He no longer has the ability to do that. Let's say you have a non-durable power of attorney. You've given someone to help a power of attorney help you sell your house because you're out of the country. So I've created powers of attorney for that specific purpose. I've nominated this person to help me sell this property under these terms, and it ends when the sale closes, right? So it's just that limited time frame, and it's usually fairly specific. But that gets into like our general power of attorney. So the general power of attorney, financial power of attorney, property power of attorney, they're used interchangeably. And what you're really looking for is the terms that are listed under the power of attorney. I've seen some really long ones. Our office does a really comprehensive power of attorney. It very generally will allow the power of attorney to do whatever the principal can do. But I've seen some very specific powers of attorney that's only for finances, right? It's a financial power of attorney, property power of attorney. But in general, a lot of people use the terms interchangeably. There's also a statutory power of attorney. California, for example, which is the only state I'm licensed to practice in, has a statutory power of attorney where it says, hey, guess what? These are the specific powers. It's just a list of things. You can initial it. You could check it off. These are the specific powers I'm giving my agent the ability to manage if immediately or upon incapacity. Remember, that's springing power of attorney. In general, I don't like California's statutory power of attorney. It's just not very helpful when you need it in reality. It's better to have it if you don't have it, if you don't have anything. But it's not really going to help you in reality the way you want it to when it comes down to it. So I like it as a last resort. At least you have one. Then you also have a healthcare power of attorney. So I'm not going to focus on the healthcare power of attorney today. But in general, the healthcare power of attorney nominates an agent, and then you're giving them some direction over your healthcare decisions. Again, I'm not focusing on the healthcare power of attorney today, but you can see how it can get a little confusing. So which one's right for you? It depends on the circumstances. If you are doing an estate plan, you're likely going to end up with a durable power of attorney. That's just the best one for everyone, gives you the most flexibility, and it's for the what ifs that are going to happen between when you're living fully and when you pass away. You just don't know. So that's why we like the durable power of attorney. Do I have to hire an attorney to create a power of attorney? Now, are you asking an attorney whether they need an attorney to create a power of attorney? How many times can I say attorney in one sentence? No, you do not need to hire an attorney to create a power of attorney. However, did you just see the list of different powers of attorney? Do you want to make sure you have the right one for you in the right situation? You want to know how to use it? So yes, you do not need an attorney to create a power of attorney. Would I recommend it? No, absolutely not. Absolutely not. Don't do it. How long does it last? Does it ever expire? We've covered this, right? If it's revoked, you've created a new one. You've regained capacity if you've become incapacitated or when you die. It doesn't ever expire unless you have a type of power of attorney that does have some sort of limitation on it. The durable power of attorney, it doesn't expire unless you expire. I just cracked myself up. Okay. If I sign a power of attorney, will I still be able to make my own decisions? If you have capacity, you can still make your own decisions. If you sign an immediate power of attorney, what you're doing is you're saying this person, the person that I don't know why I'm pointing over there, but this person over here that I've appointed as my agent or attorney, in fact, I'm allowing them to also manage my assets. So you can make the decision. Sure, you can manage it. You want to go to the bank that day? Absolutely. You want to sit on the phone for an hour and talk to your cell phone provider? You just go for it. You don't want to do that. This is why you're appointing your other person to help you manage those assets. Okay. So, but if you have capacity, if you don't have capacity, then no, you are not going to be making your own decisions. You can try, but it's just not going to work. Can a power of attorney agent be allowed to make medical decisions? Not in the state of California. You have to have that healthcare power of attorney that I talked about if you want them to be able to make your medical decisions. But this brings up a good point. If you have a power of attorney agent who's managing finances, you could have a different person making your medical decisions. If you have a different person making medical decisions and a different person making financial decisions, it's probably a good idea that they sort of get along, because what if you need a hospital bill? What if you need something financially to help you with your medical situation? They're going to have to talk to each other and figure it out, right? We don't want to end up in court because your two agents can't get along. So in California, you have to have a completely separate power of attorney. And we'll talk about powers of attorney for healthcare decisions, maybe in another one, right? Can having a power of attorney avoid a conservatorship? Most of the time, absolutely. One of the reasons why you have a power of attorney is because you're saying in this document, if something happens to me and I become incapacitated and I do not have the ability to manage my finances or make financial decisions, this is the person or people that I want to make that decision. That's one of the reasons why you have a conservatorship, is that something happens to you, you're in a coma, you lose capacity, and you don't have that document that appoints someone. The conservatorship is a court process designed to appoint someone to protect you. And it could be somebody you wanted, and it could be somebody you don't want as your conservator. So having the power of attorney for finances is one way to avoid a conservatorship. And that brings up the healthcare one, right? You've got the healthcare decisions and the financial decisions. Today, we're just focusing on the finances. Okay. Are there any risks in giving someone a power of attorney? Absolutely. You are giving someone the authority to do all of these things that are listed in the power of attorney: managing your finances, paying your bills, accessing all of your information, and trusting them to not use your money as their money, right? That's the risk. Oh, I'm behind on my rent. I'll just dip into their money and then I'll pay it back later. Like, that's a risk. So when you're looking at who do you want to appoint as your agent or attorney in fact, obviously you're going to think of people you trust not to do that, right? Again, the money stays yours. It doesn't belong to them. They can't use it for themselves, but it's a risk that they could do it. So you're looking for people you trust to avoid that situation. You're also risking, I guess, running out. So you always want to list multiple people, not just like one. What if something happens to that one person? They don't want to do it. They die too, something like that. So you want to have more than one person. Speaking of more than one person, can you have more than one power of attorney agent? What if they don't agree? Who breaks the tie? If there's two agents, can one resign? Okay, there's a lot packed in here. So you can have more than one power of attorney agent. You know, for example, you have two kids, you list both kids, they work together. If they can't agree, there is no tiebreaker. So this goes back to what I was saying previously. You're picking people you can trust. And if you do decide to have more than one power of attorney agent or attorney in fact, then you want to make sure they also get along, right? You don't want to list the two siblings who have always hated each other and they can't talk and they're not getting along. Obviously, there's going to be a problem. Oftentimes, when we have clients who want to list more than one person as a power of attorney agent, then we typically will give them independent authority. That means they can work together, manage assets, they have access to everything, but they can sort of decide who's going to divide and conquer. Maybe one's managing brokerage accounts and one's managing the day-to-day checks, but they don't have to sign every document, sign every check. They can kind of work on it together. If there are two agents and it becomes really complicated, one of them can resign. I've seen that a lot, so that there isn't always this complicated, we have to sign every check, manage everything. The two of them can decide, maybe you do it, and I'll just resign and let you go. So absolutely, make it a little easier. Can I appoint an agent who lives in another state? What about another country? Absolutely. If they live in another state right now, it's fairly easy. Easier, especially after COVID, everything can be done via DocuSign. There's banks here, there's banks there. Everything can be done via email. So it's actually not a bad idea. It's really about who you trust. That's what we're doing. In another country, I would be reluctant to be okay with somebody in a different country. Just logistically, realistically, it's probably not such a great idea unless you didn't have anybody, right? I would be reluctant to pick somebody in a different country. Does a power of attorney document have to be notarized? In the state of California, the power of attorney does not have to be notarized. We do it because there is a potential that, number one, it needs to be recorded for a real property. Then it must be notarized. And if you have a power of attorney that wasn't notarized and then the person has lost capacity, or maybe they don't have an ID anymore because it's been 10 years and they're not driving, now you're in a little bit of a pickle. Okay, so sometimes we just do it because in the grand scheme of things, why not? It's easier. It covers that what if. Also, banks like things that are notarized. It makes them feel good. It's like a warm, fuzzy blanket. And even though California law says it doesn't have to be notarized, banks just really like it. Banks, financial institutions, just in general, they like a warm, fuzzy notary stamp on that power of attorney. So again, not legally required in California, but it's just a common practice that I would recommend no matter what. You just never know. Can a power of attorney ever be canceled? Sure, we've talked about that. You've regained capacity. Here you are. You don't want this person to be your agent anymore. You decide to execute a new one. So the old power of attorney ceases to exist. Absolutely, it can be canceled. Now, if you lose capacity, it's not getting canceled. Nope, not going to happen. What if I move to a new state? Is my power of attorney still valid? Yes, it's still valid as long as it was properly executed in the state that it was done. So if you create a power of attorney here in California and you move out of the great state of California, I don't know why you would, but you could, then it is still completely valid. Some states require you to renew the power of attorney. They have like another form to make sure that it's still valid, but it is still valid. And it works the other way. If you've executed a power of attorney in another state and you move to the great state of California, as long as it was properly executed in that state, then California will recognize that power of attorney as well. I have a trust and or a will. Do I still need a power of attorney? Absolutely 100%. The power of attorney is more of an incapacity document than a trust or a will, although the trust does help with incapacity as well. Remember, the trust is managing trust assets. If you have an asset that is not in the trust, then you need the power of attorney. Otherwise, the agent, the trustee, does not have the ability to manage it. And if you only have a will, the will is not effective until you die. So that's not going to help you manage any assets while you're living anyways. So yes, that is, again, another reason why it's a great idea to have an attorney and create an estate plan with an attorney, because you can see how all of these different documents have a different purpose and you need all of them. And you need to know what they all do when the situation pops up. So you need a trusted resource to be able to ask your questions. Okay, good. We're all on the same page here. Got it. Great. Next question. I'm an agent for a power of attorney. What do I need to take to a financial institution? Okay, absolutely. You're going to want to take the power of attorney. Do you need the original? No. You definitely need a copy. If you're stepping into a situation where somebody's incapacitated, it's a springing power of attorney, then you're going to typically need those two doctors' notes, two different doctors who will certify that the principal lacks the ability to manage their finances. You stick those with the power of attorney. You like that clap? You stick them together. And so you take the power of attorney document, you'll take your doctor's notes, and then you'll take them to the bank. Do you need to take the principal who's incapacitated and can't get out of bed? No, that's why you have the power of attorney. Good, got it, excellent. Does the power of attorney get recorded or registered after I create it? No. However, like I said, if you're dealing with real property and you're the agent, and maybe you're selling the property, buying property, whatever it is, then there is a potential for it to get recorded on the property, right? Because you're signing on behalf of this person. They want that power of attorney in the chain of title, making sure that you had the power to do that. So there is the potential for it to get recorded. But is it just recorded just because or registered somewhere? No. Now, if you go to court because there's some sort of catastrophe and people are fighting and disputing over it, then there's the potential for it to get recorded at that point. But that doesn't happen that often. I mean, it happens, but not that often. My parents having some health issues and needs more of my help. I'm sorry. Can I get them to sign a power of attorney to be their agent? Maybe. It depends. So the parent has to be the one that creates the power of attorney. You can bring them to the appointment for an attorney. You can certainly suggest it, but they have to be the one that says, I need more, I need help. I need this power of attorney. And these are the people that I want to act as my agent. They have to have the ability to say that. So you can't just say, here, mom and dad, sign this. I'm going to help you. They have to have the capacity, the wherewithal to be able to make that decision themselves. Although it's a great idea, right? There is a point when parents need our help. Let's not wait until that point. Maybe that's the answer to this question. Let's not wait until that point. And then it doesn't look suspicious. We don't want it to be suspicious at all. But again, parents have to make that decision for themselves. If they cannot make that decision, it might be too late. And then you might end up in a conservatorship, right? So these are the things we don't want to avoid. We don't want to wait on them. We want to get all of this stuff done so that if the what ifs come along, we're already prepared. We already have this stuff going. I took the power of attorney to the bank and they still won't work with me. Help. Banks are the worst. Let me just say that. Oh, they're the worst. Sometimes banks just, they don't really know what they're talking about. So there's a couple of scenarios that could be happening here. They don't understand. They want you or the principal to sign their own power of attorney form. They're concerned that the power of attorney may have been revoked. It may be old, and there's no such thing. Like I said, it doesn't expire. Typically it's a durable power of attorney, which means it's long lasting until you die. But banks are worried that, they don't want to get in trouble and get sued and So in that case, it's also helpful having a friendly attorney on your side who can write a letter to the bank saying, under California law, you have to, in good faith, rely on the power of attorney. Otherwise, then we can take you to court and you can pay attorney fees. So having an attorney in your corner certainly helps with that. If the principal still has capacity and is okay completing the bank power of attorney form, then there's no harm in doing that, because generally that's the non-durable power of attorney part of it that gives them access to that just account. But in general, it shouldn't be required. And sometimes they just need a friendly letter from an attorney saying, stop messing around. It's a valid power of attorney. That's all. What are my responsibilities as a power of attorney agent? Again, your job is to manage the assets, pay bills, make sure that the pink notices, red notices, pink notices, past due notices, they're not coming in the mail. It's your job to now step in and manage the assets on behalf of the principal. And again, the powers that you have are going to be in the document themselves. So if it says, you can sell property and it's time to sell property, which don't do that unless you talk to an attorney or CPA, then you can sell property. If it says you have the ability to manage brokerage accounts, then you can manage the brokerage account. You want to make sure that these things are being taken care of. Those are your responsibilities. But are you responsible for their bills, the principal's bills, if you act as a power of attorney? For example, let's say the principal runs out of money. Are you as the agent obligated to pay the bills because you're the agent? No, that's not. Just because you are stepping in to manage the finances for the principal doesn't mean that you're now obligated to take care of them forever, right? Your money is now not there to satisfy their bills. It doesn't work that way. That's not a responsibility that you're taking on just because you're the agent. Remember, their money is their money. Your money is your money. You're just stepping in to manage the assets, the bills, the financial responsibility for the principal if they're incapacitated. You stepped in for immediately, but you're not taking on the responsibility to pay for them forever if they run out of money. I had an old power of attorney, but I lost it. And so I made another one. And then I found the first one. Which one controls? The one that controls is the one that's closest in time. So you lost the power of attorney, you made a new one, that revoked that old one. So even if you found the first one, it's the one that you just executed. That one is going to control. And hopefully it's better than the first one. I mean, that's really what you're looking for. If I'm an agent under a power of attorney, how do I sign my name? This is a great question. For example, you're going to sign for your mom, for example, Mary J. Smith by Eric S. Smith, her attorney in fact. And you know what? I think that's my last slide. So I'm going to stop my share. So hopefully I addressed, the common frequently asked questions about power of attorney. You feel more confident about using the power of attorney if you're an agent. And obviously, if you found this helpful, please like and share the YouTube video today and watch some of our other YouTube videos. And if you have any questions, you want to create a estate plan and you're in our area, please give us a call at the office. Thanks. Bye.